You first, if I can, and again, we'll take you back to your prosecutor days here.
Sure.
As Ashley and I were saying, here's what's very troubling about this case. These are not dirty cops in the traditional sense that these guys are out there selling drugs themselves, ripping off drug dealers, beating up drug dealers, taking their drugs and peddling themselves to make some money. These are guys who thought they were doing the right thing, thought they were going to be taking down a guy who was sitting on a kilo of cocaine. All right, and we know that in terms of Arthur Bruce Tesler, he was not one of the guys that fired off his gun. So he was not involved in the shooting that resulted in the death. How do you, as the prosecutor, from the very beginning of this case, get jurors to say, all right, even though he's not a bad guy, who wasn't doing a history of bad things, and they thought they were acting, a classic ends justifies the means here, how do you get jurors to say, I don't care about that. I don't care about the fact that he's a police officer. Something very wrong happened here.
Well, you have to remind people that we are the United States and we do have constitutional rights. And mavericks and lone gunmen, or people think they're doing it for the ends justifying the means. That's what we have rights here in the United States. And you need to remind people that there's protocol and there's things set in place for a reason to protect our worst and our best. So that's what you have to get through, because wearing a uniform, as I know both as a prosecutor and as a defense attorney, officers showing up in uniform when they are alleged to be dirty cops, just the uniform itself at times is almost, it helps them, because people still want to believe that cops are there to protect us and they couldn't possibly do something so negative, and like in this case, a murder occurred.
Do you think, Joanna, and I'm going to get to Peter in a minute about the defense side of this, but do you think, when I was a prosecutor, I prosecuted some police officers. When I was a defense attorney, I represented a whole lot of police officers and a lot of things here. Do you think being a police officer as a defendant in a criminal courtroom, do you get a shot at a better deal, or is it harder for you?
I think you get a shot at a better deal all day, every day, because you have to, I'll say it, as a child, what is one of the things you're taught? If you ever see something wrong, where do you run to? Where's your safe place to go as a child? And then through adulthood, as a young woman, you always look to go to the police to rescue you and to save you. So it's, even if you try to put it out there that something bad happened, you always have to remember in the back of one's head, these people are still our protectors, the people to save us. So I think that, yes, they would get a better deal, potentially, because people want to know that as jurors. And then as ADAs, let's not forget who they work side by side with the police department. So, it's not that these divisions are so separate.
Yeah.
So, yeah, I think they definitely would get a better deal.
The other side of the argument in this courtroom, then, is that that Arthur Bruce Tesler was essentially an accidental accessory to all of this here. Listening to some of what his attorney, Bill McKinney, had to say in his opening statement. And looking at the trial here, we know that the two other police officers who were involved with the discharge of the weapons pled guilty to some serious charges, some manslaughter types of charges. This former officer, Arthur Tesler, was not involved in the shooting, was in the back of the house at the time. So he doesn't have those types of charges against him. Given the fact that the two guys have already gone down for the serious stuff, are you surprised that he's actually going to trial here?
Actually, no. The reason that I'm not is that you touched on it before, and I would like to explain it. When the FBI agent called him in, it's called a proffer. And that's basically saying, do you have anything to offer me? This is basically your last chance, if you will, if you'd like to talk to me. Mm-hmm. And then his attorney will say, sure, I'll come in. But if we come in, then they do something that's called in New York a queen for a day.
Right.
Meaning that anything that we say you're not going to use against us unless we choose to go to trial and take the stand, or for impeachment purposes later on. And then basically you go and you say whatever it is that's happened, and based on that information, you try to work with them to see of getting a plea agreement, and that you will that you will collaborate with them and cooperate to go forward. So I'm surprised that he didn't take a plea deal, but not super surprised, because if we look at a timeline, you have that Junior took a plea deal, and flipped.
Right.
And then you have that Smith flipped. It's almost like first in time, first in right.
Yeah.
They beat him to the punch. So they're already going to testify against him. What does the FBI need him anymore for? what does the DA need him anymore for? Because now you got 2 against 1, except if you want to close the case.
Yeah.
So
we say oftentimes it's a race to the courthouse steps. First one there is going to get the best deal. Yeah.
It's not about that he wanted to do the right thing. I don't believe that one for a second.
Yeah.
I think that literally who beat him to the courthouse steps, and that there was so much on the line of what he could risk them as far as how many years he could go to jail for, that basically it was a toss-up. He said, all right, I'll go to trial.
Right.
However, what we also see is that you have federal versus state. And I think the federal...
You know what, Emma, hold that thought, Joanna, because I want you to elaborate on that a little bit, because I think that takes some explaining here in terms of the concurrent jurisdictions sometimes for these types of things. So hold that. We'll get back and we'll talk about that. But in the meantime, let me fit in a quick break here when we come back. More of that testimony, including in a little while the defendant himself.
The good fortune to interview the prosecutor in this case, Kelly Hill, but I felt like she was a little bit cagey at times. I totally get it. She was put between a bit of a rock and a hard place. These are people that she has to work with. She depends on the Atlanta Police Department to do her job.
Right.
And I asked her if she thought that her job would be compromised in the future by having to go ahead with this kind of a prosecution. Look, she was adorable. She was terrific. She was so diplomatic in her answer, but I never really expected to get the straight dope from her. You're a former prosecutor. Right. What do you think? Like, would you have wanted to go after a case like this?
As a prosecutor, I take my job seriously. I would have no problem going forward with this. But I also have to have open eyes and know what I potentially could be labeled as. But I do want to just go back on the question that you just asked as far as confusing the jury.
Yeah.
I think that it's very important as I am as a criminal defense attorney that you have good props. And this is a confusing just case because there's so many hands in the pot, literally. Then you should have good charts for the jurors to keep reflecting upon, and then once you get them admitted into evidence, then you have them posted so that way they could keep everybody straight, because that way you could have a good flow chart to tell them what's going on.
So it's not just a stupid suggestion to actually have a picture map of all the faces of the players.
We do it all, but we do it all the time, because a lot of times when you get caught up in the minutia, sometimes it's the minutia that are actually the plans of reasonable doubt that you need to get caught up in. It's the specifics, especially let's say if you have a pathologist. You have to go through every little thing, and it's boring.
You just reminded me of something that I always bring up and Jack can't stand. It's the OJ case. Jack, 9 months plus of testimony and evidence, some of it so unbelievably ironclad. DNA, which was kind of new to everybody. Do you think that jury got a little confused?
Well, I think it's not that I can't stand it. It's just I spent 9 months in that courtroom back and forth, and it was a lot of time. I think they did get confused. You know, I interviewed most of the jurors after the trial, and I think it was a long, complicated case. I think most people agree the prosecutors made it more complicated than it had to be, and they were offered up by Arthur Tesler about first his initial involvement with this unit, some of the things that he was told, a little bit shady, some of the things they told about having some throwdown drugs left in the car there, and then talking about, again, the details leading up to all of this. Let's talk a little bit with Peter Gleason and Joanna Greenwald, who are our guests here. And Peter, I will start with you. Looking at this case and looking at the charges, do you think that Arthur Tesler had any real choice about whether he was going to testify or not?
I really don't think he did. He, along with his attorney, needs to humanize him, and I think he's doing a good job of that. He's thrown it out on the line, and I think that will bode well with the jury.
Joanna, what do you think? Any real choice about him testifying?
About him testifying, or about him saying something or speaking up for himself with the other cops?
Well, let's start off with him testifying. Do you think, did he have any choice, or did he have to get on the stand to tell his story?
Well, I just want to go backwards in what I said. Once he testifies, any proffer or any agreement he may or may not have had, or anything he said in the past, can now be used against him. And that proffer is what they're arguing about, the 8 hours of not being taped. That's the agreement I'm talking about. His attorney was there the whole time it allegedly wasn't taped. So if he took the stand and chose to take the stand, he was doing it knowing they could use all of this information against him.
Right.
So it's a heavy decision he made, and I think that something must have been going on that he felt he had to, and that a plea deal wasn't good enough, and since the other two already flipped, then either whatever,
left with no choice, basically.
If anything that they offered him, because in this case, I just would like to point out quickly, in this case, we're dealing with a bad search warrant. And in New York, what's known as the Aguilar-Spinelli test. And we have an Aguilar-Spinelli violation where you need not just reliability when you use a confidential informant, you need a basis of knowledge and corroboration. The corroboration part is the thing that went completely out the door.
Right.
Because there was no CI, which is confidential informant, there was no buy, and all three cops, Tesler, I know we're asking questions about what a cop should know, should have known. He knew all day long that you needed corroboration here. How else were you going to this house?
Yeah.
And that's what the fight is about, is what he should have known and what did he know at the time.
If you look at this, and Peter, let me bring you in the conversation, looking at this, do you get the same sense that I do, that probably whatever was offered to him as a deal was just way in excess of what he was willing to plead to? I mean, if you look at the second count, I don't know that he has a defense to the second count. Giving the false statements to the FBI where they went the whole script they put together and they fabricated this buy. I don't know that.
In that case, we've got the information for you, and we're going to give it to you. So in the meantime, got to say goodbye to our guests, Peter Gleason and Joanna Greenwald.
Thank you.
And thank you both for all your insight, and look forward to the next time you guys are coming back. Take care, guys, and when we come back, the new information that might not bode well for this